Succession, Articles 774 to 795 of the New Civil Code. Article 774. Succession is a mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another or others either by his will or by operation of law. Succession is a mode of acquiring ownership. The modes of acquiring ownership are the following: 1. Occupation, 2. Intellectual creation, 3. Prescription, 4. Law, 5. Donation, 6. Testate and intestate succession, and 7. In consequence of certain contracts, namely tradition. For succession to take place, the following must concur: 1. Death of the predecessor, 2. Existence and capacity of the successor, 3. Provision of the law or provision of a will granting the right of succession, and 4. Acceptance by the successor. The parties to succession are 1. The decedent or the transferor, and 2. The successor or the transferee. Let us clarify some terms. Testator is the decedent who left a will. Intestate is the decedent who did not leave a will. Heir is one who succeeds by universal title or to a share of the estate, and devisee is one who succeeds by particular title to real property. Succession is a mode of acquisition of inheritance transmitted to the heirs upon the death of the decedent through a will or by operation of law. The rule is the estate of the decedent pays for the obligation of the decedent. What is left is given to the heirs. For money debts, if not paid in settlement proceedings, the heirs could be liable to the extent of what they received. For obligations, like in a lessor-lessee relationship, the obligation to keep the lessee in the peaceful possession is transmitted to the heirs. Article 775. In this title, decedent is the general term applied to the person whose property is transmitted through succession, whether or not he left a will. If he left a will, he is also called the testator. Under this article, every testator is a decedent, but not all decedents are testators. Article 776. The inheritance includes all the property, rights, and obligations of a person which are not extinguished by his death. Transmissible property, rights, and obligations constitute inheritance. The following are guidelines on whether rights and obligations are extinguished by death. Number 1. Property rights and obligations which are purely personal are extinguished by the death of the decedent. They are not part of the inheritance. For example, membership in the bar or right of consortium with your wife. Number 2. Those which are purely patrimonial. General rule, they form part of the inheritance. For example, credits. Exception, money debts. Obligation to pay is not transmissible, although purely patrimonial, because the estate pays for it. Number 3, those obligations transmitted to the heirs which are not monetary, for example, obligation of a lessor which is patrimonial. For example, B leased to C a parcel of land for a term of 3 years. After 2 years, B died. The heirs of B are bound by the lease contract. Obligation as lessee and bailee are transmissible. Article 777. The rights to the succession are transmitted from the moment of the death of the decedent. The following are the elements of succession: 1. Death, 2. Will or operation of law, 3. Existence and capacity of the successor, and 4. Acceptance. Rights to succession vest at the moment of death, not transmitted. The right should be made effective from the moment of death. Rights to succession are vested from the moment of death, not upon the filing of petition for testate or intestate proceedings. The rights to succession are automatic. Tradition or delivery is not needed. During the lifetime of the predecessor, rights to succession are a mere expectancy. Hence, no contract can be legally entered into regarding the expected inheritance. When an heir receives his inheritance, he is deemed to have received it at the point of death. This is so by legal fiction to avoid confusion. Article 778. Succession may be 1. Testamentary, 2. Legal or intestate, or 3. Mixed. Testamentary succession is provided for under Article 779, where there is a designation of an heir in a will. Legal or intestate is one without a will or the will is invalid. Mixed is provided for under Article 780, wherein the succession is partly by will and partly by operation of law, and compulsory pertains to succession to the legitimate by a forced heir. Article 779. Testamentary succession is that which results from the designation of an heir made in a will executed in the form prescribed by law. Heir includes devises and legatees. Article 780. Mixed succession is that effected partly by will and partly by operation of law. Article 781. The inheritance of a person includes not only the property and the transmissible rights and obligations existing at the time of his death, but also those which have accrued thereto since the opening of the succession. Example: A has a son X. A dies in 1988. Inheritance is a mango plantation. In 1990, there is a crop. Is it part of the inheritance? According to Article 781, yes, it is part of the inheritance. Article 782. An heir is a person called to the succession either by the provision of a will or by operation of law. Devises and legatees are persons to whom gifts of real and personal property are respectively given by virtue of a will. Article 783. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate to take effect after his death. The word person in this article refers only to natural persons. Why does the law say permitted to control to a certain degree? Because heirs cannot be deprived of their legitimes. If there are no compulsory heirs, the power of the decedent to dispose of his estate is absolute. But if there are compulsory heirs, he only has a limited degree to dispose. That is why the will can only cover the disposable portion of the estate, what we call the free portion. The following are the characteristics of wills. Number 1, it is a purely personal act. It cannot be delegated, and the personal participation of the testator is required. Number 2, it is a free act. It means without fraud, violence, deceit, duress, or intimidation. It is voluntary. Number 3, it is dispositive of property. The exceptions are, letter A, when a will recognizes an illegitimate child, B, when a will disinherits a compulsory heir, and C, when it appoints an executor. Number 4, characteristic of a will is that essentially it is revocable. It is ambulatory. It is not fixed. It can be taken back while the testator is alive. There is no such thing as an irrevocable will. It only becomes irrevocable upon the death of the testator. Number 5, it is formally executed. If the form is defective, it is void. It cannot be cured. Number 6 is the testamentary capacity of the testator. Number 7, it is a unilateral act. It does not involve an exchange of values or depend on simultaneous offer and acceptance. Number 8, it is mortis causa. It takes effect upon the person's death. Number 9, it is a statutory grant, granted only by civil law. The law can also take it away. It is not a constitutional right, but merely a statutory. And finally, the 10th characteristic of a will is animus testandi. There must be an intent to dispose mortis causa the property of the testator. There must be a real intent to make a will or a disposition to take effect upon death. Said intent must appear from the words of the will. Article 784. The making of a will is a strictly personal act. It cannot be left in whole or in part to the discretion of a third person or accomplished through the instrumentality of an agent or attorney. The making of a will is a purely personal act. It is an exercise of the disposing power which cannot be delegated. But the physical act of making a notarial will can be delegated to the secretary, but not the execution or making of holographic wills. Example: A dictated to his secretary, and the secretary wrote it down and typed it. Is the will valid? Yes, the will is valid. What cannot be left in whole or in part to a third person is the exercise of the will-making power, the exercise of the disposing or testamentary power. The mechanical act can be delegated. Article 785. The duration or efficacy of the designation of heirs, devisees, or legatees, or the determination of the portions which they are to take when referred to by name, cannot be left to the discretion of a third person. Under this article, the following cannot be delegated to a third person by the testator: 1. The designation of heir, legatee, or devisee. 2. Duration or efficacy of such disposition. And 3. The determination of the portion to which they are to succeed when referred to by name. Article 786. The testator may entrust to a third person the distribution of specific property or sums of money that he may leave in general to specified classes or causes, and also the designation of the persons, institutions, or establishments to which such property or sums are to be given or applied. Examples of prohibited delegation. 1. The testator cannot delegate the designation of the amount of property. For example, the will says, I hereby set aside the sum of blank, which my executor may determine for the cause of mental health. The amount here is not specified, therefore the delegation is prohibited or not valid. Number 2, the testator cannot delegate the determination of causes or classes to which a certain amount is to be given. For example, the will says, I hereby set aside 1 million for such worthy causes as you may determine. This is not valid because the cause is not specific. This kind of delegation is prohibited. By way of exception to the general rule that the making of a will cannot be delegated, the following are valid delegations. Number 1, the designation of person or institution falling under the class specified by the testator. For example, the will says, I hereby set aside the sum of 1 million for the development of AIDS research, and the testator chooses X to be the one to decide which institutions are to receive the grant. This is allowed. This is a valid delegation because the decision of X is already guided by the testator, namely that he will choose only institutions that are engaged in the development of AIDS research. Another exception is the manner of distribution or power of apportioning the amount of money previously set aside or property specified by the testator. For example, the will states, I designate the following hospitals to get the share in my estate and appoint X to apportion the amount of 10 million. I set aside 250,000 for the following institutions: UP and PGH, in an amount as my executor may determine. In this situation, the executor is given the authority to determine exactly how much these hospitals are entitled to, and this is a valid delegation. Article 787. The testator may not make a testamentary disposition in such manner that another person has to determine whether or not it is to be operative. This article explains what is meant by a will is personal. This is in effect delegating the discretion to the disposition of the will. Article 788. If a testamentary disposition admits of different interpretations, in case of doubt, that interpretation by which the disposition is to be operative shall be preferred. Article 789. When there is an imperfect description, or when no person or property exactly answers the description, mistakes and omission must be corrected if the error appears from the context of the will or from extrinsic evidence, excluding the oral declarations of the testator as to his intention. And when an uncertainty arises upon the face of the will as to the application of any of its provisions, the testator's intention is to be ascertained from the words of the will, taking into consideration the circumstances under which it was made, excluding such oral declarations. There are two kinds of ambiguity, the patent or apparent and the latent or hidden. The patent or apparent ambiguity is that which appears in the face of the will. For example, the will states, I give one half of my estate to one of my brothers. Who among the brothers? This is patently ambiguous because it does not specify which of the brothers is entitled to the disposition. The second type of ambiguity is the latent or hidden. The ambiguity does not appear until you apply the provisions of the will. For example, I give to M the property intersecting Buendia and P. Rojas. The ambiguity appears only when the will is probated. If the ambiguity is patent, disregard the will. If latent, look into the evidences allowed by law. Article 790. The words of a will are to be taken in their ordinary and grammatical sense, unless a clear intention to use them in another sense can be gathered, and that other can be ascertained. Technical words in a will are to be taken in their technical sense, unless the context clearly indicates a contrary intention, or unless it satisfactorily appears that the will was drawn solely by the testator, and that he was unacquainted with such technical sense. Article 791. The words of a will are to receive an interpretation which will give to every expression some effect, rather than one which will render any of the expressions inoperative. And of two modes of interpreting a will, that is to be preferred which will prevent intestacy. Article 792. The invalidity of one of several dispositions contained in a will does not result in the invalidity of the other dispositions, unless it is to be presumed that the testator would not have made such other dispositions if the first invalid disposition had not been made. Article 793. Property acquired after the making of a will shall only pass thereby as if the testator had possessed it at the time of making the will, should it expressly appear by the will that such was his intention. Article 794. Every devise or legacy shall cover all the interest which the testator could devise or bequeath in the property disposed of, unless it clearly appears from the will that he intended to convey a less interest. Under this article, the general rule is, legacy or devise will pass exactly the interest of the testator over the property. The exception is, unless it appears from the will that he is giving less. For example, you own a parcel of land. Only the ownership of the land can be given. If the testator is a usufructuary, he can only bequeath his rights as usufructuary, nothing more and nothing less. However, the testator may give a lesser interest. For example, the will says, I give the usufruct of my land to X. What is the result? The usufruct goes to X, but the ownership of the land goes by intestacy. Article 795. The validity of a will as to its form depends upon the observance of the law in force at the time it is made. As to formal validity, we have time criterion and place criterion. The time criterion refers to the law at the time of execution. Subsequent laws cannot apply retroactively. As to place criterion, the testator have the following choices: 1. Citizenship, 2. Residence, 3. Domicile, 4. Execution, and 5. Philippines. As to intrinsic validity, time is the time of death, and place is the law of citizenship of decedent. This is the end of part 1.